Hai, Assalamualaikum to our business law lecturer Encik Muhammad Nazir bin Muhammad Adi. We are from group 15. Today our group will be present about company policy on termination of employment at pandemic COVID-19 from a fair and justice perspective. For abstract, government. Currently, the spread of COVID-19 virus is growing rapidly. Not only in Malaysia, but almost cities in Malaysia implement large-scale social restriction, referred to as MCO, Movement Control Order. The Movement Control Order means that all activity are carried out at home to slow down and stop the spread of the COVID-19 virus, including studying, worshipping, working, and socializing. For company, because in this COVID-19 season, there were many Malaysians who lost their job because the company could not bear the cost of salary to its employees. They lose their company sources of income. Therefore, they have to lay off their employees for the goods of their company from being affected. For termination of employment, since the current situation is equally new to the employee, the fate affected by the termination of the employment relationship is a callback or vice versa. In this regard, it is important to consider the aspect of specificity and fairness in company policy by consider that on the one hand it will increase the number of unemployed in Malaysia, while if the company retains its employee increases, then the company could potentially incur losses leading to bankruptcy. For pandemic COVID-19, because of COVID-19 issues right now, the termination of the employment is one of the big issues in Malaysia. For the introduction, according to the Director General of the World Health Organization (WHO), has declared that COVID-19 is a pandemic. Because of this, the pandemic situation is very severe and very alarming, which is causing death to humans. Prime Minister Malaysia announced on 13 March 2020 that the spread of coronavirus infection 2019, as known as COVID-19, in Malaysia is increasing. Update of the total number of cases in Malaysia on 25 June 2021, there are 722,659 people who have been infected by the COVID-19 pandemic. Affected economically as a result of the outbreak. There are workers who are instructed to take leave, work from home, and even a handful of them lose their jobs. Huge losses for all sectors in Malaysia as a result of this pandemic. As such, the issues from this article is a concept in terms of contractual fairness and the appropriateness of termination of employment to this COVID-19 pandemic situation to the concept of fairness and justice. That's all for me. Thank you.
Hi, I'm the next presenter. My name is Siti Karijan Tizaini and I will explain in the discussion part. That is the position of law on determination of employee. In Malaysia, states that employment contract relationships are regulated by the Labour Relations Act in 1967. In Section 20, provides that any employee who believes they has been wrongfully terminated by his or her employer without justification or excuse clarify an interpretation with the Director General of Industrial Relations in less than 60 days of the termination date. According to Yeo and Jack, there are 7 categories of just reasonable excuse for terminating a work contract, such as misbehavior, retrenchment, poor performance, retirement, revocation of a genuine fixed-term contract, resignation, or by a mutual agreement. An employee believes they may be fired instead of just valid cause may make a written request be reconsidered to his or her former position. Next is termination of employment on COVID-19 pandemic in the perspective of justice and fairness. Employees who pursue the protocol can terminate an employee without having caused unfair implication to both of the employer and the employee. Employees who pursue the protocol can terminate an employee without having caused unfair implication to both employer or the employee. Employee will be legally permitted to terminate benefits and awards if they are deemed untrustworthy. There are 2 types, such as substantive justification. Instead that the employee may not be fired unless there is a valid reason for doing so. This is related to the worker's potential or conduct is based on the operational requirement of the undertaking, establishment or service. Next one is procedural justification. The employee is required to investigate the allegation made and to listen to his employee's explanation so that employee can develop a balanced opinion on the matter at side. That's all from me.
Assalamualaikum, my name is Sharifah Nur Ain, AP 180437, and I will proceed to the case study. Next is perspective of employment termination due to the COVID-19 pandemic on fairness and justice. The relationship between the employer and the worker will take effect after the signing of the employment agreement. Based on Employment Act 1955 under Section 10 of EA stipulates that if a service contract requires a worker to work for more than 1 month, the contract must be concluded in the writing and include a termination clause by either the parties. While the EA do not apply to all the employees, the worker can actually use them as a reference when reviewing their employee's contract, so they can identify terms that may be unfair to them. Furthermore, in Malaysia, employers can bypass contract employees only for employees to want the only reason and grounded for unfair decimal in the Section 20. The reason for the termination receiving willful misconducted performer, renouncing, and the business of Baker. Under Section 12, either the party in the signing ceremony intend to the end the contract of the under the party at any time. So, due to the coronavirus pandemic, also send the shockwaves through the business and forcing company to make difficult job decision where their employees. While the virus has directly resulted in the layoff, and some companies, industries, and business may be forced to terminate employees' contract prior to the disease outbreak, putting in a difficult position and giving the current economic climax. This is because during a pandemic, the company income decrease affected the employees' wages. That's all for me. In this research, we have 2 points for the case study. For the first one, in contract agreement in the concept of fairness and justice. Justice in the context of Malaysian is the guarantee that everyone is equal before the law and even has the right to equal legal protection. It is stated in Part 2 of the Federal Constitution, Section 8. Fairness and justice is involved in the contract formations process and can be introduced through the statutory interventions. In the field of contract, it is not uncommon for the party to the transaction to face perceived unfair consequences at some point. It is a natural outcome of the fundamental principle of the contract freedom. So all the agreement are contract made with the free consent by the competent parties for the contract for lawful consideration with a valid object that are not expressly proclaimed void. It is stated in the contract at 1915 under Section 10. So next is, for example, in the section 13 reflect the principal consequence at the idiom, which state that two people have been said to agree when they agree in one same thing and in the same sense. According to the general law, if the consent was not obtained independently and also the party is complete the contract due to the presence of the formations, a voice factor which is entitled to avoid the contract has provided under section 19. So the lastly, the contract at 1915 and has interpreted by the court, which is to examine whether and to what extent modern contract law values such as fairness and justice have influenced the law.
Good evening, doctor. My name is Xiu Hong. My tree number is AP190085 from Group 15 Business Law Section 5. Now, I would like to present about the critical evaluation. First, justice and fairness is a condition where it's committed to expand benefit to each gathering during its prevalence and commitment. Besides that, justice can be classified as legitimateness because it is reasonable if a standard is applied to all situations, whereas indicated by its substance is for sure the standard to be applied. It is uncalled for it a standard is applied to one case yet not in other comparative case. Furthermore, by following the justice principle, it said that it was in line with the principle of justice when the working relationship was terminated due to the COVID-19 pandemic. Therefore, Section 60F and 60E of the Employment Act 1955 is the guideline on quarantine order, retirement, leave entitlement, and health scanning among employees during the COVID-19. Under Section 60F, employers are required to provide a paid sick leave or hospitalization entitlement for the duration of hospital treatment for patients confirmed to have symptoms of COVID-19 infection. Besides that, according to Section 60E 1B, employees who are given a quarantine order or a home surveillance observation order cannot be forced to use annual leave during the quarantine period. If the employer did not follow this Employment Act, it can be identified as unless the law or injustice. Besides that, according to Section 60F, when employees are in quarantine, the employer cannot use employee unable come to work as a reason to dismiss them, and the employer must pay salary to the employee. If the employer did not pay any salary to the employee, we can identify this as injustice, but if the employer reduce the employee salary, it can be identified as fairness for the employer. Therefore, as a short conclusion, when someone doing the right thing means that did not break the law and moral, then what she did can be called as justice.
My name is Tako Hong and my matrix number is AP190081. I'm the last presenter and I would like to present implication and conclusion. COVID-19 pandemic is a virus that will cause the country in the global to meet a lot of negative problems such as economy, healthy, business and also people's livelihood. Government will produce Malaysian movement control order to reduce the case. COVID-19 pandemic will bring the big impact to the business, especially the maintenance costs for the company such as worker salary and also utility. To reduce the case, some companies use the method of shut down their business temporarily to reduce the cost of salary, rental and the utility. So that company policy on termination of employment and pandemic COVID-19 from a fair and justice perspective is the most effective method. The principle of fairness and justice in a condition where it is devoted to maximize profit by means of each party doing its right and obligation. The company meets the principle of compliance if on agreement already lists the right and worker when it does PHK because the company performs efficiency. The principle of self-compliance is not only regulated in law but can be annexed in the employment agreement. If the company does the termination of the work relation as the company perform efficiency, it is better to give information to the previous worker and show data related to its income, and we hope that the COVID-19 pandemic will dissolve and once a day is coming in all countries. Thank you.